Hello, ladies and gentlemen. My name is Tim Gagan, and I'm a lawyer in Quebec. What you're going to be watching today is for legal information purpose only. It does not constitute a legal advice. If you have a real case, if you need a real legal advice, please contact your lawyer. If you need more information, here are several useful links. If you need a lawyer and you don't have a lawyer, please contact the Law Society of Quebec, Barreau de Quebec, and they will help you to find one. Hello. Latent defects. Vis cachés. Vis cachés is more commonly spread uh, kind of words when it comes to this problem, especially in Quebec, of course, but the civil code in English calls it latent defects. Latent defect is something, when it comes to immovable, is something that makes this immovable of less value, either temporarily until the repairs are done, or even permanently if something is impossible to do, like basement cracks, wall cracks, flooding, groundwaters, something like roof leak, uh, bad ceiling over the windows, heat leaking outside, mm, pipes, plumbing, electricity problems that make or might make even dangerous to use this property, and so on and so on and so on. It's not only a problem right away, it might accelerate the degradation of the property, put it in danger, and all everybody in there in danger. So it's serious. It's not something to be taken easily, and therefore there are a lot of court cases about latent defects. There are two sides, of course, as you can imagine. Buyers want sellers to pay or to do the repairs, which might cost a lot. Uh, Sellers, on that hand, they don't want to participate. They claim that the buyers knew or should have known what they're buying, and that such a claim is unfair and sometimes even unconscionable. And all that goes before a court, before a judge, and goes on and goes on and goes on. So, what should you know before you enter into this kind of deed, this kind of contract of sale and purchase of an immovable property in terms of a latent defect? First of all, the defect should be latent. If it was disclosed in writing or manifestly disclosed before the purchase took place, it's not a latent defect. So if the buyer knew, or as they usually say, should have known, meaning that the defect was apparent and was just immediately visible during the visual inspection, then the defect is not latent, and the seller is not responsible for that, which makes it rather tricky for a buyer to trust the seller about the condition of the property the buyer is buying. The buyer should do due diligence and to look around and to see what's going on. If ever the case goes before a court, or even becomes a matter, and there is some kind of negotiation, there will be a question like if the buyer was informed, first of all, about the defect. So if the seller knew about the defect, the seller should have informed the buyer. So was he informed? If the buyer was informed, if the seller can prove that, then that's usually the end of story. The defect is not latent, and there is no case. That's it. But of course, the seller might say, yes, the buyer knew about the defect, but there will be a question of proof. So if the seller says, yeah, you knew about that, what's your proof? Something in writing, some email, text message, or better, some signed paper from both sides, or the form which is usually filled where the defects should have been mentioned. All that plays in favor of the seller if that happened. If the defect was not disclosed, then again the question is, was it apparent? Was it immediately visible? So if you go around and there are cracks on the basement, on the walls, but for whatever reason a buyer thinks that it's decorative or just doesn't pay attention, or think that later on it might be resolved with the seller if there is a problem. No. If it was apparent from the beginning, then no latent defect. Uh, of course, there is a gray area, because sometimes to see a crack, to see a water leak, to see something rotten, you have to remove stuff, for example, or maybe it's winter, so you cannot really see the condition of the roof, at least from outside, and maybe some parts of the building. So what might be then discussed is if it was possible even for a duly diligent buyer to uncover the defect, to go around, to look inside, to see. And also there is a question if what's apparent, what's seen, if it's a good indication of defect. Because, for example, some kind of decoration of the foundation of the building looks like it was on purpose covered with some kind of decorative cracks, and then the seller might say it was immediately visible. It would be up to the buyer to say, no, what I saw is decoration, not a defect. Also, there might be something small, which on its own not a defect, but later on it might appear that under the surface this small crack becomes a big crack, and there is some groundwater flood or something in there which makes the floor rotten in the basement, for example, or the wall goes curly or whatever. So if there is an indication, then it's on the buyer to go to follow the indication and see if there is anything behind that. And again, as I said, it's a gray area, because at some point the buyer might say, well, I'm not a specialist, I don't know if this is an indication or not. And the seller would say, like anybody who's buying a house, buying this kind of property would know. So it'd be up to the judge to decide if a reasonable person at the level of knowledge of this buyer or around that would have understood that it might be a problem or not. Again, it's not 1 or 0, it's not black and white. It might be analyzed if, of course, the parties cannot get to an agreement before the case goes before a judge, goes to the court. So basically the judge would ask the buyer, were you diligent? Were you serious about inspecting the property? And if you were, how can you prove that? Of course, again, if there was an indication, what the buyer should have done, because, well, asking the seller is one thing. The seller might say, oh, to my knowledge, no, there is no problem. And it's not hiding, because the seller might honestly, in good faith, have no knowledge of what's going on. So some court cases suggest that if you see an indication of something that might be a problem, you as a buyer, it's your responsibility to hire a specialist, an expert, to understand what's the extent of the problem. Is there a problem, and what's the extent of the problem if there is one, and what's basically the cost of repairs, because that would allow you to negotiate the price. And probably that's what you would want to. And if even after that the seller would firmly say that no, there is no problem, then later on, mm, the fact that the seller said that could play against that seller. Well, again, if you kept the evidence is a usual cornerstone of any case in court. Maybe you hired an expert, an inspector, not an expert. There is a difference. The inspector is somebody who is sort of responsible for looking around diligently, seriously, and attentively for you. The inspector is not an expert. The inspector should not be able, or at least it's not responsible to be able to tell you what's the extent or potential problem. But the inspector should have noticed the indications of a potential problem and advise you if an expert is needed or not. Again, if the seller knew about the problem, then even if you as a buyer were not diligent, were not serious, you did not hire an inspector, or inspector just missed something, then it will be still the seller's problem, the seller's responsibility, because the seller knew and should have disclosed it to you. But again, do you have proof that the seller knew? If you don't have that proof, it would be more diligent to get a good inspection, because later on, if you didn't do that, you would blame yourself and you could not blame the seller. This is, again, this is sort of a grayish area, because clear cases usually do not go to court. They're resolved in negotiation, because, well, going to court in a clear case would only add to expenses to the party who is at fault. But when it's not clear, like, was it visible? Was it not visible? What was the time when you came? What could you see in that season? And because of the fallen leaves, for example, or because of the snow, or because of a rainy day, or again, because it was very dry for a long time and you couldn't see if there is any water leak through the ceiling or the windows or the door or garage door or something like that. That's something that might play in your favor, might play against you. But the question would be, can you prove that you were diligent, that you were serious, that you were attentive? For example, if the weather did not allow you to get closer look, did you try to come again and to take that closer look later? If you were not happy with what the inspector has done, and you're not sure if there is professional responsibility of that inspector, or if you did not understand the inspector's report properly, what did you do to understand? And if you saw some indication of or possible indication of some problem, what did you do to understand if there is a problem or not? And what information did you ask, and how insistent you were from the seller? On the side of the seller, of course, the question would be, if you knew of the defect, if you knew, you should have disclosed. If there is an allegation that you knew but you didn't, is there any reasonable explanation? How could you not see that while you were using that property, while you were living there for a significant amount of time, and so on and so on? So as I said, it's a gray area, and if you're ever in this kind of a conflict, you'll need documents and documents and documents, maybe testimonies, to prove your point. So it's better to think in advance how that might go, and maybe prepare yourself and know your property better before you sell it, maybe do some repairs in advance and disclose whatever you think might be a problem, because once it's disclosed and the buyer agrees to that, it's no longer your problem.